As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction. May it please the court. My name is Rwan Hardesty, and together with my co-counsel Jason Larmon, we represent The Appeal of It, a podcast designed to distill Texas Supreme Court opinions, Texas Court of Appeals opinions, and other Texas law to make it all more appealing.
Hi, I'm Jason Larmon, and I'm a co-host of The Appeal of It, and I'm here with Rwan Hardesty, and today we're going to talk about something a little different. We have, quite often, questions about mental health. Mental health is something that impacts a lot of families, and it, quite frankly, makes a lot of headlines. So if you look back at modern headlines, recent headlines, you'll see a lot of cases, especially the high-profile murder cases, where mental health plays a big factor. There's the Idaho stabbings recently. We're recording this in August of 2023. We just saw conviction and sentencing of Lori Vallow, which was another mental health affected case. And one of the questions that comes up quite often is, how do we deal with mental health cases in the criminal context, in a criminal case where someone's committed a crime? And there's a complicated structure, but it's one that is designed to both serve the interests of justice and to serve the people who find themselves sort of caught up in those cases. So, for example, one of the questions a lot of people ask is, if a person is suffering from mental illness and they commit a crime, can they use not guilty by reason of insanity? And the answer to that is actually several steps in the making. So in Texas, what we do is, the first step is we look at whether a person is competent to stand trial.
Okay, what does it mean to be competent to stand trial?
So competent to stand trial, and there's some very specific language that I'm sure the legislature put a lot of thought into, but essentially it's, does the person understand the proceedings, what's going on in the courtroom, and can they participate in trial strategy and in trial with their lawyer in such a way that there's a meaningful contribution from them, right? Because we can't expect an attorney to take someone who doesn't even know what the jury's role is, or what the judge's role is, or what his own attorney's role is, and expect them to be able to meaningfully prepare for trial with that person unable to assist them in even the most basic preparatory steps. And we also don't want to put someone into a situation where they don't even understand that they're on trial or what the effect of that is. So step one is the person competent to stand trial? And that process is a very easy thing to kick off, because the legislature wants to make sure that everybody going into a trial at least knows what's happening. And so the first step in the process of an attorney meeting with a new client, preparing for trial, or maybe somebody who has a family member who they know suffers with some mental illness that has a pretty significant impact on their lives, the thing to do is to bring that up to the judge. And that can be done basically just by telling the judge, we think we have an issue with competency. You can file a motion, but ultimately you just need to get it in front of the judge. And the way the code's written, and it's in the Code of Criminal Procedure under Article 46B, essentially what you have to do is you have to bring it to the attention of the judge, and the judge is expected to perform what's called an informal inquiry.
Okay, so let me back you up just a little bit, because you just referenced the Code of Criminal Procedure.
Yes.
Are there any other codes that are specific to criminal cases or in Texas, or is that kind of where we start?
So that's where we start on a mental health situation, where someone has been arrested for a crime, charged with a crime, and they're starting to come to court for pretrial hearings and those types of things. That's where Article 46B sort of takes over and directs the path going forward.
Okay.
So judge would perform an informal inquiry, and in my experience, quite often that's nothing more complicated than maybe a few minutes talking to the attorney or a few minutes talking to the defendant to just get an idea of why we're concerned about competency. Once that process takes place, and honestly, in an abundance of caution, most judges want to be sure, so they will refer them out to an expert to evaluate them for competency. Okay. So the expert will sit down with them. They'll kind of go through sort of their refined process to kind of figure out if the person can understand courtroom proceedings, could potentially, discuss things with their attorney, things like that. And then depending on that determination, then we move to the next step. So
what kind of expert would that be? Would it be a psychiatrist, a psychologist, a licensed professional counselor? What kind of?
So ideally someone like a psychologist. And I believe the code has some specific parameters on sort of who the ideal experts are there. Most judges already have an expert that they use in these cases, so it's not a road that you have to pave yourself. Okay. You can sort of just get on the train as it leaves the station and not have to sort of reinvent it at this stage. Later it gets a little more complicated. So that expert's going to be looking for things like, does this person have the mental capacity to understand this new information that's coming to them, right? Because somebody who's never been in court before may not know the answers to any of those questions either. They might not know how to work with their attorney or what the judge's responsibilities are versus the jury and things like that. But the expert's going to be looking for things like their ability to interpret and accept that new information and then incorporate it into their understanding. Okay. So it's not unusual for someone, especially with an untreated mental illness, to struggle with incorporating new information into sort of their world. It's also not unusual to have someone who has a mental illness that affects their views on sort of the world around them, or their connection to, I guess, the reality we need them to see going into a court.
Can you give us an example of what that would potentially look like?
So I can cite, I can think of situations where, both. For example, with regard to the first one, I remember a case where the defendant just could not process new information, right? It was either that they couldn't retain the information or they didn't understand it. And so it didn't matter how many times you told them, this is the judge's responsibility and this is the jury's responsibility. If you brought them back the next day or an hour later, they wouldn't remember that information.
Okay. So that kind of reminds me a little bit of having, say, pregnancy brain or something to that effect, kind of to bring it to the audience a little bit.
Right. So, but that's one of the things that we do here. And it's important to recognize that this is a very preliminary step in the process. So to give you an example of sort of the other end of that sort of range of possibilities, I can remember a defendant who was found to be incompetent, but the reason she was found to be incompetent was because she had a very complex narrative in her mind of how reality functioned. And her version of reality was very, very different from the one the rest of us live in. And because she had created this alternate reality, she couldn't realistically consult with her lawyer and explain why she had done or not done the things she was accused of doing. Okay. So if her lawyer tries to get her to explain something and she immediately diverts over to a topic that's, 3 degrees removed from that, that becomes a very difficult situation for an attorney to adequately prepare for trial and to adequately represent that person in the event that the case goes to trial. And so in those situations where there's a determination that the person is incompetent, obviously if you find them competent, then they just go back to court, things pick up and move on. Okay. So if you've got someone who's found to be incompetent, then we start down sort of the longer road. And the way Texas has structured it through the legislature is that a person who's found to be incompetent basically ordinarily begins a process where they try to restore that person to competency. And most communities, most judges, again, have already sort of laid the groundwork for this process. So it's a very sort of well-defined path. But essentially what happens is they go to a mental health treatment facility and they're put on, supervision from a psychiatrist who hopefully finds the right combination of medications to treat the mental illness that they're suffering with, and also helps educate them on the court process and how to best navigate that process from the... Go ahead.
Finish your sentence and I'll ask my question.
How to navigate that process as a defendant so that when they are, if ideally successfully returned to competency, they're prepared for those moments where they're sitting in a courtroom working with their lawyer and things like that.
Okay. So are we assuming here that the defendant that has been found incompetent has been in custody, so in jail or prison at this point? Or is there a situation where this defendant could be out on their own recognizance or bail or bond?
Both options are possible.
Okay.
Practically speaking, it's very, very common for certain members of the population to be more likely to be incompetent. For example, one of the things that I've seen in practice is that a significant portion of cases like criminal trespass committed by someone who's homeless are cases that are affected by someone with mental illness, right? There's not a lot of people who choose to be homeless and remain homeless for very long who are not suffering with some form of mental illness. So it's very common in those situations for it to be a person who, if they do get arrested for even something as minor as trespassing, wouldn't have the resources to then make bail, get themselves out of jail, go hire their own lawyer, and so they quite often end up in the system, but also in custody while they're awaiting sort of the next phase. Okay. There are absolutely avenues to do either outpatient treatment or things like that where the circumstances fit, but at least in practice, I think a lot of judges prefer the inpatient route for the restoration process because it gives them such a more intensive experience, and the chances of getting them the help that they need and also helping them to be competent are more likely to be successful.
Okay, so I guess my follow-up to that is if you have somebody that's out on bond or that is awaiting trial outside of custody, mm-hmm. and you find them incompetent in some way,
yes,
then would we have a situation where putting them in custody in a psychiatric hospital cause an issue with their due process or their right to be free during that time period? Or, I mean, would they be illegally restrained at that point?
So they wouldn't be illegally restrained. Again, there's factors involved in it, but ultimately we want the least restrictive means. So if a judge determines that this person has a competency issue, but based on the report from the expert and everything else, that it's, given the broad spectrum of possibilities here, one of the more easily treatable mental health conditions, they might feel that a outpatient program, to the extent that the community has an effective one, could be an option. To the extent that the judge doesn't feel that way, or that there's not a functioning or highly successful outpatient program for competency restoration in place, then at that point it would move to an inpatient treatment facility. Okay.
So as an attorney that I have dealt with some mental health situations where, not in the criminal context, but specifically where what we call a person has been white warranted into a mental health facility. Mm-hmm. Is that kind of the same scenario because they're only allowed a certain amount of time that they can stay in, they're appointed an attorney, they're taken, all their due process rights are taken into account, but is that a completely separate process than what we're talking about here?
Yes, it is.
Okay.
So in essence, in this situation, they're under the control of the criminal judge, just like a defendant who's out on bail or in custody or anything else, and that carries with it certain conditions that they have to comply with.
Okay.
And in this particular instance, one of the conditions would be that you have to perform whatever competency restoration is done. I have seen cases where judges will trust an existing psychologist or an existing psychiatrist who's been working with a particular patient to take on the responsibility of restoring competency in sort of an outpatient setting that's already familiar to the defendant. But unfortunately, at least in my experience, the majority of patients end up in an inpatient setting. So if you're in that situation where you have somebody who's out and they're perhaps working and things like that, look for those options, but understand that they don't exist in every community. Okay. So if we get to that point where we've got somebody who's now been sent to, for example, an inpatient facility, the code puts them there for, I believe, 60 days. So for 60 days, they're in sort of an intensive program that's designed to get their medications aligned, get whatever additional diagnoses need to be put in place, get those conditions as well managed as possible, and also work towards competency restoration. Obviously, some conditions are treated more easily than others, and some of those will come back a little quicker than others. And in the event that that treating physician or those treating facilities feel that the person has reached competency, whether that's in 5 days or 45 days or ultimately at 60 days, then they're to notify the court and let the court know that this person, they believe, is now competent. And quite often, once that recommendation is made, then the person returns from the facility and things resume where they were when the whole process got started.
Okay, so now putting the horse or the cart before the horse, if at 60 days, or maybe that's your next topic or segue, at 60 days, what if they're not found competent?
So it depends on the case. And the reason it depends on the case is because in the legislature's infinite wisdom, they determined that in a misdemeanor case, that's the most we should be putting somebody through this in order to specifically restore them to competency.
Okay, so what is a misdemeanor case?
So a misdemeanor case...
In Texas.
Right, so there's a lot of different things, but essentially there's a hierarchy. The more serious cases are felony cases, the less serious cases are misdemeanor cases. So misdemeanor cases are going to be things like possession of marijuana in reasonable amounts.
So just as an FYI, Texas is it's still illegal to have marijuana as of this date in your possession.
Yes.
So.
Yes. So possession of less than 2 ounces of marijuana would be a Class B misdemeanor. Theft under certain amounts would be either a Class C or a Class B or a Class A misdemeanor. Things like criminal trespass. Obviously, most of the driving offenses, things like that, would be misdemeanors. Some of them would reach the point where this process kicks in.
So is it like a certain amount of jail time or a certain fine for misdemeanor cases? So these lower types of cases?
Yes. So essentially, anything that's punished, anything where the maximum punishment would be a year or less would essentially be considered a misdemeanor. And then anything where you were looking at 2 years or 5 years or 10 years or 99 years, those would all be the felonies. And it affects things like which facilities you spend your time in and things like that, because misdemeanors, you serve it in a local jail. Felony cases are quite often served in state institutions and things like that. So misdemeanors are going to be our less serious offenses, and therefore we're less willing to sort of keep somebody suspended in a mental health facility while we work things out.
Okay. So then for a felony, then what's the maximum? So
with a felony, the court is granted the authority to extend it an additional 60 days.
Okay.
So if you reach the end of the 60 days and the efforts have been unsuccessful, but the treatment facility or the treating physician is of the opinion that this person could likely be restored before the end of an additional 60 days, then there's an opportunity to extend it. And there's an off-ramp there that I think you heard me allude to, and that is if the treating facility, the treating physician, comes to the conclusion that no matter how long we keep this person, we're not going to restore them to competency, then there's no benefit to justice to continue to try to restore them to competency for that additional 60 days. So one of the things that that treating physician needs to determine is, would an additional 60 days be likely to restore this person to competency? In the event that the answer is no, we'll get to that in a little while. In the event that the answer is yes, then the process essentially renews and they continue for some additional time in trying to restore that person to competency.
Okay. And so now they've been found competent, they end up coming back to court. You start where you kind of ended up. So if you were at pretrial, you would start at pretrial.
Yes, the process just picks up again where it goes. So, and this is where we sort of hit a fork, because we're either going to restore the person to competency or we're not going to restore the person to competency. And in the event that we do not restore the person to competency, they're not fit to stand trial, and it would be a deprivation of their constitutional rights to put them on trial.
Okay, so what do we do with them?
So...
Or is that a big Pandora's box that I just opened up by asking that question?
No, that's a very good question, because quite frankly, I've had judges look at me and say, what do I do with this person? Because it's an unfamiliar point, because generally speaking, we don't hit that point with people, but it does happen. So the question changes at the end of that 60 or that 120 days, and we move from, does this person understand the proceedings and can this person consult with their lawyer, to, is this person a danger to themselves and is this person a danger to others?
Okay.
Because now we're no longer worried about, can we get them ready for trial, which was our original objective. Now the question is, how do we protect this person and society? And sometimes the answer is they're not a danger. So for example, the person who's homeless and has a network of family that maybe have been alerted to the situation because of the criminal case getting started and, you know, the facility reaching out or whatever, that person may now have a network of support that makes them not a danger to themselves and not a danger to other people. And in that situation, quite frankly, what normally happens is those cases get dismissed.
Okay.
We end the criminal justice involvement in that person's life, and we sort of turn them over to their network of family and support that they have. And that works in some cases, and in some cases it doesn't. The more complicated ones are the ones where the person is believed to be a danger to themselves or is believed to be a danger to others. And to sort of draw up a couple of examples, we had a case where a defendant got arrested for making explosives. And he was using sort of his free time to build quite a number of small explosive devices. And when police went in and executed a search warrant and found these explosive devices, he also had a list of the attorneys and the judges and the officers who had been involved in his arrest that had sent him to prison years earlier, which, as you can imagine, was quite alarming for law enforcement, because that's a person who's exhibiting some dangerous behaviors. So when it was unsuccessful at restoring him to competency, the next step was, is he a danger to himself or others? And when the experts who looked at that, it was two different psychiatrists, sat down, evaluated him, both came to the conclusion that this was a person who was a danger to himself or others.
Okay. So I heard you say there were two evaluators in this instance.
Yes.
And is that kind of a fail-safe that would normally occur?
Yes. So the basic step of moving forward down this avenue, which is called civil commitment, requires the opinion of two experts. Okay. So before a judge even has this opportunity, they need to have supporting opinions from these two experts. And they have written reports, and they've spent a lot of time with them and really tried to sort of dig into this person's past, really try and get a good understanding of them. So in that particular instance, just because we'll use it as an example, the experts said, yes, he's definitely a danger to himself or others. He needs to be in a civil commitment facility. So he's, at that point, placed in sort of line to get into a bed at a state-run inpatient facility. And those are very secure facilities in most instances because these are people who have been found to be dangerous, even though they're not currently facing an active criminal case, because that's all been put to the side. So in that instance, he spent some time there. They eventually came to the conclusion that he was no longer a danger to himself or others after a couple of years. So again, we need the opinions of two experts. Those two experts came to the conclusion that this person is no longer a danger to himself or others. And they eventually came to the conclusion that releasing him was the right thing to do.
So he was there for 2 years. Is there like a annual or what would, if you can remember, what is the increments that evaluation should be
Once
done?
a year.
Once a year.
Yeah,
Okay.
so a civil commitment order in Texas is written for 1 year. And just like with the competency thing, if we hit a point that's significant in less than that time, those facilities have the mechanisms to have their staff or their people come in, do a new evaluation at 3 months, 6 months, 4.5 months, whatever it is, and work through that process and form an opinion about whether that person's competent. Excuse me, not competent,
No.
but no longer a danger to themselves or others.
Okay.
To cite sort of the opposite outcome, I can remember a case where 18 or 19-year-old kid was suffering from some very severe mental health issues and ultimately ended up ending his mother's life. It was a very brutal murder. Everybody was very confident there were mental health issues. Ultimately, that was borne out as the experts got involved and began looking closely at his mental health history leading up to it and his behavior during sort of the process. Every year, I can remember the experts would sit down, reevaluate him in the facility that he's in, and very reliably they would find that he was still not competent to stand trial because, unfortunately, he was someone who was dealing with mental health issues that even with the best treatment they could provide for him didn't end the potential for him to be a danger to himself or others. And so he has never stood trial, and he will likely never stand trial for those crimes, but he will remain in a treatment facility for as long as necessary to keep him from being a danger to himself or others, which at this point in time, given the passage of time, appears likely to be the rest of his life.
Okay. That's too bad.
It is too bad. Now, in the event that we don't go civil commitment because the person is found to be competent or they're restored to competency, then what happens? Well, the next question that a lot of attorneys need to be asking is, was this person's mental illness affecting them at the time they committed whatever offense it was? Because that's where we start talking about things like not guilty by reason of insanity. So now let's go back and we'll talk about when you've got somebody who has been put into the competency restoration program or who has maybe found treatment before they ended up there, but who at the time that they were doing the thing they're accused of doing, and quite often has done, was suffering from mental illness.
Okay.
And what do we do with that person? Because, again, just like we don't want to put somebody on trial and punish them for things that, through a process they don't understand, we similarly don't want to punish someone for things that were controlled completely by their mental illness or were caused by their mental illness when we can treat the mental illness instead.
Okay.
So that's where you enter terms like not guilty by reason of insanity, right? So essentially not guilty by reason of insanity is the person certainly committed the offense, right? The physical act that they're accused of doing definitely was something that they did. But their responsibility for it is viewed much differently in the law.
Okay, so do we have a big example of that people can kind of hang their hat on?
There are quite a few examples of that. One of the more, I guess, headline-worthy cases in my lifetime has been the Andrea Yates case out of Houston, which is a heavily litigated case where it initially was, she was proven guilty of murder, and then the case was eventually reversed, sent back for a new trial, and the outcome of that second trial was that she was found not guilty by reason of insanity. I think a lot of people are probably familiar with that case, but essentially it was someone who, over the course of their life, eventually came to be raising 5 of their own children with their husband. And there's a lot of reporting on it, and I don't want to misspeak about the facts of the case, but essentially she drowned the kids. And over time, more has come out about sort of her deteriorating grip on the same reality that the rest of us live in. And obviously it was a very heinous crime, but ultimately what happens in a case like that is we acknowledge that they committed the crime, but because of their mental illness, we treat them very differently, or quite frankly, sometimes it takes away things like the intent, right? The person who might physically harm someone else by accident is much less responsible for their behavior than someone who does it entirely on purpose. And the law has always recognized that, and specifically with mental health, it may move them less into that less responsible category because of the mental illness. So essentially what would happen in the case of a not guilty by reason of insanity is, yes, they performed the act, but they didn't have the mental state necessary to have done it intentionally where it's required or knowingly where it's required and things like that.
Okay, so they're found not guilty by reason of insanity, or in other jurisdictions, I believe that it's by mental defect or some other similarly phrased indication that it's a mental health issue. Then what do you do with them? Are they released into society at that point? Or does that matter on whether they're...
So then we enter a very similar framework to the one we talked about with civil commitment, where we have a sort of a renewable process where if an expert determines that they're a danger to themselves or others as a result of that mental illness, then they're put into either an inpatient or an outpatient treatment program that's aimed to assist that person in treating that mental illness. So there are cases I can think of where, again, a year or two down the road, that person has been treated, they've been treated successfully, we've found the right combination of medications, we've sort of been able to stress with them the importance of taking those medications reliably. They now are doing very well. And in fact, the case that comes to mind was a situation where a young kid I say young kid, 19 or 20-year-old, had gotten into an altercation with his stepfather. He'd injured his stepfather pretty severely and was facing an aggravated assault charge. And they went through the competency process. He was ultimately found to be competent by the end of it. He was put on trial. They ultimately agreed with the state that not guilty by reason of insanity was the most appropriate outcome, and he was placed into that process. And after about 2 or 3 years, he had been treated consistently, reliably. They were confident with it. They had a sort of an end goal of putting him back into society with the support necessary to do that. And the way they did that in that particular case is we moved from an inpatient program to an outpatient program. In other words, he was in a hospital facility and then he was out living in the world, but doing it under the supervision of a team of treating professionals. So in his particular instance, the facility was able to work with his attorney and with his family and create a sort of a comprehensive plan. So they'd made arrangements for where he was going to work. They'd made arrangements for where he was going to live. They'd met with the various members of that household to make sure that they were all aware of and comfortable with the situation and knew the things to be on the lookout for as part of that outpatient program. And he was eventually transitioned into a situation where he was back living with his family again, and he was able to sort of go on and be successful.
But he had a support system in place at the end of the day.
Yes, and ultimately it was a support system that was built as a part of that not guilty by reason of insanity avenue that he found himself on, right? He didn't already have those resources in place when we sort of ended up there in the first place. And through that program, through the state involvement, through the professionals that were able to help identify and treat his mental illness, and then ultimately transition him out, a support system was built around him. So just as sort of a thought experiment, if you had a defendant who's committed, say, a violent crime, right? And the one that comes to mind is sort of the Idaho stabbings case, right? So to sort of put a timeline on it, in Texas, you would have a situation where his attorney would first question whether he was competent to stand trial. And in the event that he was not competent to stand trial, we would start that process, send him down that road of trying to restore him to competency, help him understand the proceedings, help him consult with his attorney, help get his mental health under control to a point where it's being treated, and then kind of see where we end up. If we found that person restored to competency, then we move into the question of whether or not their mental illness was effectively the cause of the crime that they committed, right? Because there are lots of people who commit crimes that have mental illness, but it's not a cause and effect situation, right? Having a mental illness is not any type of get out of jail free card or a license to commit crime or anything like that. But in the somewhat rare instance where the mental health has a causative effect on the outcome of everything, then we have this more specialized avenue that allows us to get that person the help and the treatment that they need with state involvement, state intervention, and state supervision. And ultimately you have especially in the felony case, you have a district court judge who's ultimately tasked with making the final decisions in those instances.
Okay. And just real quick, here in Texas we have district courts, which are in other jurisdictions probably the superior court level of courts, I believe.
Yes.
And so we all name them different things, and just know that the district court is our trial level court.
Yes, yeah. So and we can even take it one step further. In Texas, we've talked about misdemeanor versus felony. A misdemeanor case would be in a county court. The vast majority of counties, their criminal cases are done in county courts at law. And then you would have a district court, which would handle all of the felony level cases and things like that. So.
Okay. So I think you kind of alluded to the fact that if it's the mental illness that caused the person to commit the crime, that's the jury question or the finder of fact question.
And I think I'm kind of paraphrasing the exact language there, but essentially the committing a crime coexisting with having a mental illness doesn't get you there. We need to have some way that they're interconnected. So when you have some of the more severe mental illnesses, the behaviors are quite often driven by that mental illness. And so ultimately what we're really looking towards, and again, there's so much nuance to mental illness and everything else that it's very difficult to put too sharp of a point on it. But essentially we're looking for a connection between that mental illness and the crime that was committed.
Okay.
Because if, again, the mental illness was what was the driving force behind committing that crime, that person needs to be treated with very different tools than someone who consciously made the informed decision to rob a convenience store or things like that.
So what happens when somebody who may have done something due to the mental illness, that there is this causal effect, and after the event or the crime has been committed, they realize that it was not the greatest idea to have done that, or they realize it was bad what they did? How does that play into all of this?
So it definitely would, I mean that's almost the ideal scenario in terms of society as a whole, right? We want people to be able to reflect on their past behaviors and acknowledge when they've made mistakes. Generally speaking, somebody who has that level of self-awareness and everything else will find themselves eventually competent to stand trial, right? And it may be that they don't realize it until they've been through a competency program or things like that, but it's definitely something that does happen by all means. That doesn't necessarily undermine the not guilty by reason of insanity option. And the reason for that is that not guilty by reason of insanity is focused on a very specific moment in time, right? We're looking at, because again it goes back to that cause and effect thing, we're looking at whether your mental illness affected your behavior that day or those days that we're specifically looking at for purposes of the criminal conduct. So the fact that you had untreated mental illness when you were 18 wouldn't necessarily play much of a role in terms of not guilty by reason of insanity when you're 26. But if you were still struggling with that same illness when you're 26, that's something we need to look at very closely. Now, the next possibility is that you were suffering from mental illness. Maybe you suffered with mental illness your whole life, but you don't meet the criteria for civil commitment. You were found to be competent, but you don't meet the criteria for not guilty by reason of insanity. And the question then becomes, what happens to that person? You know, what do we do with the fact that this person is mentally ill? It obviously is making life much more challenging for them. It may have put them on the road that led them to perhaps a drug addiction or things like that. How do we deal with that situation? And ultimately, that's a heavy burden for attorneys to take on, but ultimately that type of evidence, those types of events in life, need to be brought into the discussion when we talk about punishment, right? Because again, we want to treat people fairly for their particular situation. And so an attorney who finds themselves in that situation where not guilty by reason of insanity is either something that they've tried and they've been unsuccessful at, or that they've made the determination they don't simply have the facts for, they need to then sort of change directions and start preparing for how to present that evidence of mental illness and the effect that it's had on this person in terms of helping either the judge or the jury to find the appropriate punishment for that person.
But it wouldn't affect the guilty, not guilty phase.
That's correct.
Okay.
Yeah, it may come into the case at some point, but the most impactful point for it will quite often be during the punishment phase, when we're trying to figure out what the appropriate punishment is.
Right. And again, kind of to bring it back into how Texas courts work, and I'm sure a lot of other jurisdictions do it this way as well, but we have a guilt, innocent, or guilty, not guilty phase. That is the main trial. And then if they're found guilty, then you go into punishment phase, essentially.
That's correct. So in Texas, what we have, and I'm not going to speak to other jurisdictions, but as far as I know, they all do it this way, is we have the very narrow question of, did this person who's on trial do this specific thing they're on trial for? And generally speaking, we don't want to know in that stage what they were doing years earlier, or if they've ever done it before, or anything like that. We generally try to, as much as possible, focus on the specific conduct that they're on trial for, and everything else gets, with some exceptions, pushed out of the way. And then when we move into sort of the person has now been found guilty and now we're in the punishment phase, that's when we want to talk about things like how they struggled in school, or this is the 11th time that they've committed this same crime and they're clearly not learning their lesson. Things like that become relevant at that point, and that's where, especially in a mental health context, their attorneys should be putting together as much evidence as they can on their medical records and their treatment and the analysis that's been done by some of these experts and things like that, to try and compile as clear of a picture of how mental illness has affected this person, so that whoever's making that punishment determination has the ability to really incorporate that into finding the appropriate outcome there.
Thank you for listening to Jason about mental health and the structure here within Texas and how it would go through the system if somebody is found to be incompetent. And we'll see you next time.
As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction.